In the event that they do arrest somebody, that whatever they do to your car, they will characterize it as an inventory search.
Yeah.
Because with an inventory search, they do not want you picking up your car and then saying, what happened to the sacks of gold coins I had in this car?
Right.
Where are they? You took them, cop. Why'd you take my sacks of gold coins?
We are the Armed Attorneys. Today we are answering your questions. A lot of fun stuff is on the docket, talking about police searches with firearms with regard to serial numbers, taking it out of your center console. Can postal employees carry into post offices in the wake of the Second Amendment Foundation and the Firearms Policy Coalition decision, and carrying one in the chamber, and so much more. But before we begin, show your support for the Second Amendment by hitting that like button. And if you enjoy this stuff, check us out, armedattorneys.com. About halfway down the page, we have our newsletter there. Just your email. We don't spam folks. We send stuff out infrequently. But if you want to stay in touch with some breaking news, that's the place to find us. Edwin Walker, thank you for joining us.
Oh, it's a pleasure to be here.
So we got a bunch of great questions from you folks. If you have a question and you want to get it answered on a future episode, type it out. It really helps if you add question, state your question, and then hopefully we can get to it. But let's start off with you, Edwin. I'm going to read you this first one. This is from Ron8566. Should you not share the handle of info folks asking questions? Sorry, Ron. Could that be discoverable information? And could that result in a bad outcome if folks who submit a question? What do you think about that?
That question's relatively antagonistic.
Yeah, that's good.
I mean, it's accusatory.
Yeah. Let's hear it.
Stop sharing my name. Stop sharing my handle.
No, that's not what he's saying. He's saying, could this be used against folks, in a future situation?
Well, of course, you'd never ever ask an attorney a question that starts with the word could.
Yeah.
Because if you start with the question could, the attorney's going to go, well, yeah. I mean,
anything's possible.
Anything's possible. I mean, we don't have a crystal ball. It's not foreseeable. And this is anything that you ask a YouTube channel is not privileged.
Yeah.
And so I'm assuming that these questions are the questions they write in the comments.
Yeah.
So they're
Yeah,
in the event there was a prosecutor who wanted to find this, which would be really out of touch with the way I understand most prosecutors work. They're not going to go digging around through this.
They're lazy?
I'm saying they're not going to dig through this. But just remember, anything that is shared on social media, anything that you put out in the public or even in a semi-public private forum, that's not privileged. And anybody can find it generally. The only thing that is privileged with regard to us as attorneys is information that is disclosed by our client that is done, with the intent of it being privileged, and it has to be shared just between the attorney or an employee of the attorney and the client. So not your friend can't listen. In fact, just the other day I was speaking to a client and I had to ask his wife to leave the room.
Yeah, I had a similar situation.
Yeah, just so I could be sure and maintain that privilege. So in the event that you are engaging in a privileged conversation, make sure there's nobody else around, nobody hears it. Do not disclose the contents of it to any other person. That is what is truly privileged. Everything else is discoverable.
Yeah, and I'll ask you folks. I mean, let us know down in the comment section, should we stop sharing handle names? We do. We screen the questions a little bit. We read through, see things that are interesting, not interesting. If somebody, don't post sensitive information on YouTube, for God's sakes. These are all hypothetical, fun questions, trying to make y'all's lives a little bit easier. But I'm interested to see what you folks have to say, so let me know.
Yeah, and clearly we're not, if somebody were to ask, dear armed attorneys, I am...
On March the 1st,
I currently have a 21-year-old woman chained to a bed in my guest bedroom. I feed her once a day. Should I increase that to twice a day?
Yeah, that's suboptimal. Not the kind of question we want to see.
No.
All right.
Okay, let's move to question number 2. I'm still under the effects of that previous question. Should I even read this individual's handle?
Yep.
Okay. Duobnib193. Question. I have a CCP. I guess
Chinese Communist, concealed carry permit.
Or CCCP, which was the old handle for the Soviet Union.
Yep.
In my home state, plus a multi-state Utah license. I travel by myself 99% of the time and always carry concealed. and I am injured in a car accident serious enough that I require transport by ambulance to the hospital. What are my options for my concealed carry? The car is most likely going to be impounded because of the accident. We have actually had this happen
We've
before.
had this happen more than once. A couple of things. First off, and this comes up because a lot of states, they prohibit possessing a firearm inside of a hospital. Sometimes they have notice requirements, sometimes they don't have notice requirements. But think about this, you're badly injured, maybe it's on your person and they take you to the hospital. Are you committing a crime by
Maybe you're unconscious.
Yeah, are you committing a crime because you're possessing a firearm in a hospital? The short answer is no. I mean, part of a crime is a voluntary act, and so if you're unconscious, if you're being transported by other people, that the law isn't designed to target that kind of behavior. Let's say it's left inside your vehicle, you're transported away from the scene, your vehicle is being taken away. What typically happens is what we call an inventory. And that's where the police, before, handing it off, the keys off to the record driver, they will go through and either log or gather all valuable personal property. So sums of cash, jewelry, firearms, electronics, that kind of stuff. Because we don't want the situation where, all right, you recover, you come back, and all your stuff's missing. There's no record of any of this stuff. I'll say that is typically the practice. Obviously, your mileage may vary, but generally, one, not a crime in the hospital because involuntary. The second, impounding, you have that inventory.
Yeah, crimes, the vast majority of crimes, in fact, I would say almost all crimes, require a mental state. Usually that's intentional, knowingly, could even be recklessly, but even recklessly includes the fact that you know what you're doing, you're just disregarding it. So, yeah, when you have a completely involuntary act, that's not going to be used against you.
All right, next one we have noticing to share. Let's see, this is, I have a firearm, for example, in the center console and not on my person, and a Leo gets me out of the car and I do not consent to a search of the car. Can the Leo still go in, so Leo law enforcement officer, still go in and retrieve the firearm legally?
Well, that is a very interesting question because yes, and it's kind of interesting. You said the LEO removed you from your car. I don't know if that would have any bearing. Certainly, if you are going to get out of the car, usually it used to be common practice that people would get out of their car. Now the police officers may say, get back in your car, and they're supposedly doing it for your safety. Because obviously if you're out of the car, you could get hit by an oncoming car. That's their argument. But vehicles have held a very, very unique place in Fourth Amendment jurisprudence. And that it goes all the way back to the 1930s. In 1981, there was a very important case called Belton, which basically gave the authority to the police to search cars all the time, anytime that they arrest somebody. Keep in mind that in most states, you can be arrested for pretty much any offense that you commit, including traffic offenses. In fact, here in the state of Texas, I think there's only 3 traffic offenses for which you can't be arrested. So
I thought there's 2: speeding and open container. What's the third? I won't put you on the spot.
I think it's insurance violation.
Oh, okay, all right.
I think it's
but you can't
not
drive
having
without
proof of insurance.
Okay, all right, I'm with you.
So, but there are very few. And so if a policeman wanted to, he could arrest you. Now, the Belton decision was limited several years ago, over a decade ago, by a case called Arizona v. Gant. And in fact, there were a lot of folks, a lot of academics that advocated for a complete overturning of Belton, that it had gotten too out of hand, it had gotten too broad, it was too subject to abuse by the police, which I agree with. And the U.S. Supreme Court did not expressly do that. However, their ruling in Arizona v. Gant did strictly limit the excuses that police officers could use to go ahead and search a car. However, there's one huge caveat, and Richard just alluded to it in his previous answer. In the event that they do arrest somebody, whatever they do to your car, they will characterize it as an inventory search.
Yeah.
Because with an inventory search, they do not want you picking up your car and then saying, what happened to the sacks of gold coins I had in this car?
Right.
Where are they? You took them, cop. Why'd you take my sacks of gold coins? And so they will always use that excuse. Now, I myself, I am always been in favor. I know this is obviously Second Amendment channel. We all love our First Amendment rights, but folks out there, I cannot tell you how important it is to advocate for your Fourth Amendment rights. In fact, my fantastic Fourth Amendment, my criminal procedure professor in college, unfortunately, she has passed on, and her husband, who is also a law professor, he has passed on. But she was a very fine lady, and she used to say, "They're kicking the guts out of the Fourth Amendment. They're kicking the guts out of the Fourth Amendment." And even though she was saying this in 1990, the same holds true today. They are, in fact, yes, kicking the guts out of the Fourth Amendment.
Yeah, because you think about general rule, can't be subject to unreasonable search or seizure. So many exceptions when it comes to vehicles because the courts have basically said, hey, look, these things can be driven away. There's not time to obtain warrants. And so that's kind of their justification for getting in there. Now, another common one is officer safety, things within your wingspan. It becomes more difficult when you're out of the car, away from it. But while you're in the car, with the door open, standing near it, I could see a court going either way on that. But it is a really, really good question.
And in the event that anybody does find them in a situation where they have been arrested for a possession crime, because that's what we're talking about. We're not talking about that were robbing a liquor store or doing something. We're talking about crimes of possession, possession of something the state has declared you can't have. In the event you find yourself in one of these situations, always, always, always have your lawyer fully explore any possible Fourth Amendment issues with regard to that.
Yep.
Next question is Earl Winters, EP7HK. I guess he must like HK. Yeah. I, too, am a huge fan of the HK. I have several, many myself, including some really cool ones. But unfortunately, not the most important one.
No.
Not
the one that everybody wants.
Not the one everybody wants, including myself. Question. If the PO says he is going to run the serial number on weapons, you say, I don't consent to that search.
Yeah, they search the gun. They still run the serial numbers. So it's a good question, and what the courts generally hold, these types of numbers, they say they're non-testimonial. So you think about incriminating yourself or information that would, somebody would have an expectation of privacy of. The courts just don't go along with any of that stuff. We don't agree with it, but that's what the courts say. And as far as think about this as an inverse way of thinking about a rights violation, what would be the remedy if they discovered it's a stolen gun? Well, you can't transfer title to a stolen gun, so you can't have the title. They take the gun away from you. So the scenario where, hey, look, they run the number, it comes back with some information that causes the police to seize it. There's so many issues tied in with that there aren't a lot of remedies to, the problems that come up. There's not really remedies for the person to solve. So, it's obviously something you talk to your lawyer about, but there's not a silver bullet there.
Yeah, once they, let's say, hypothetically, they do run the serial number, they find out it's a stolen gun, boom, you've just lost any kind of property interest that you may have in that gun. Therefore, you have no standing to complain.
Yep. All right, this one to you, Edwin. This is Papa DeChico. Question. I'm a postal employee. I became a member of the Second Amendment Foundation. As an employee, am I still prohibited from carrying inside? How about if I keep the firearm locked, secured box in my vehicle that is parked in the employee parking lot?
Well, as an employee, first of all, you kind of have to distinguish. You're wearing two hats. So whenever you go to the post office as a customer, you have your customer hat, and so you have
fall
all
into that
the
ruling.
rights to carry. When you're going to work as an employee, you're covered under your postal hat, and we don't want anybody going postal. So unfortunately, you would have to abide by the rules and regulations established by the post office.
Yeah, because you think about the court didn't address the question as to whether a governmental employer can prohibit their employee from carrying. That question hasn't been answered yet. They were just looking specific to the question about Second Amendment Firearms Policy Coalition members, these two named plaintiffs, carrying in these standalone postal facilities, not in federal courthouses, military bases, things like that. So you see, probably not going to be covered.
And here we have our last question, which is a practical question. Doesn't really have any legal consequences, but It's just kind of a question that all of you gun folks would enjoy and can weigh in on what your personal preference is. Comes from Andrea Lincoln. Andrea Lincoln. Is it Andrea Lincoln?
Yeah.
And Real Lincoln. Yes.
Okay.
2793. Sorry, Andrea. This isn't exactly law related, so if you pass on it, no worries. What are your opinions on concealed carry with one in the chamber? Ooh, with no safety on the firearm. This is coming from another female. You think this was directed to persons?
It was,
other than
and so
us?
that's why I texted Emily and Leslie.
Yes.
I got a response for it.
Thanks for these videos. I live in Ohio, but they always give me something to think about.
All right, so what are your? I'll get to the ladies' responses, but what do you think about carrying one in the chamber?
I mean, she did emphasize that it did not have a safety.
Mm-hmm.
I would think, where are you carrying this? So
Well, it could be a Glock.
it could be a Glock, and the thing about it is that what you should remember is you just think in an emergency situation, are you going to have time to rack the slide?
Yeah, so think about the scenarios that you think you might find yourself in, and that's really what it comes down to. What keeps you more safe? Carrying one in the chamber, is that going to put you in more danger? You know, maybe you have little ones around. Maybe you don't think you can carry it safely, you know, especially if you had a firearm without a safety. Think about the scenario, hey, if this isn't going to make me, you know, less safe, then it might be your best option. I mean, I personally, one in the chamber. Leslie said, without one in the chamber, it's a paperweight. So, you know, it really is a personal preference. I would say carry the way that you train. You know, there's folks, I have a buddy who trains with, he doesn't carry one in the chamber, and he practices quick drawing and racking and shooting. You know, so it just, you know, whatever you're comfortable with.
Or you carry a revolver that has a concealed hammer.
Yeah, there you go. Yeah, a little hammerless revolver. That's a good idea.
Yeah.
All right, but these are great questions. If you have any more, leave them in the comment section down below. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. Also, you can check us out at walkertaylorlaw.com. Full service criminal defense here in the greater Houston area. And until next time, we're the Armed Attorneys.